Tonight, the state Supreme Court is considering next steps for our state's Fetal Heartbeat Law. It went into effect back in 2023 and banned abortion after the detection of a fetal heartbeat.
But today they were talking about when that fetal heartbeat is considered viable. It's a lawsuit from Planned Parenthood saying the limit should actually be 9 weeks and not 6 weeks. Josie Frost was at the hearing today and has more for us tonight. Josie.
The Supreme Court today heard arguments on the law, which up until now has banned abortions after 6 weeks. But Planned Parenthood asked the court to look at the term fetal heartbeat, which was used in the law. They say that at 6 weeks, a fetus hasn't formed yet, so there can't be a fetal heartbeat.
Simply put, you cannot have a fetal heart or a fetal heartbeat without a fetus.
You're going to hear the consistent heart rate of the unborn child when you do the ultrasound.
The Supreme Court today hearing arguments on the latest question over the state's abortion ban. When does a fetal heartbeat occur? Up until now, it's been considered a 6-week ban, which lawyers for the state argue was the clear intent of the bill.
There is blood pumping through the unborn child at the end of the 5th week. That is all evidence that says there's a heart, it's functioning, there's a steady and repetitive rhythmic contraction.
But Planned Parenthood is challenging that notion, saying that at 6 weeks, a pregnancy would be considered an embryo and not a fetus, meaning there can't be a fetal heartbeat even if there's cardiac activity.
The undisputed facts in the record here show that through 9 weeks gestation, the developing pregnancy is called an embryo, not a fetus.
A similar bill was struck down in 2023, which the court says violated a right to privacy. This new law was passed later that year, which the courts upheld. The justices say if they uphold the law, they need more clear definitions for doctors to use to interpret it.
You can't just tell a doctor don't perform an abortion after 6 weeks. You've got to give the doctor some objectively discernible criteria to use in determining whether he or she can go forward with what the patient is asking them to do.
While today's hearing was just for the injunction, the court could go ahead and make a final ruling based on today's arguments. They could rule that the law clearly points to a 6 or 9 week marker, or say that the law is unconstitutionally vague. Either way, a decision isn't expected for some time. Josie Frost, News 19, WLTX.
All right, Josie, thank you so much. Meanwhile, Attorney General Alan Wilson released a statement on today's arguments before the Supreme Court about the fetal heartbeat bill. Here's what he had to say. He said, "This is my 3rd time that my office has gone to the state Supreme Court to fight to uphold our state's Fetal Heartbeat Act. The legislature's intent was clear: to protect life once a heartbeat is detected. We thank the justices for their attention and thoughtful questions and look forward to their ruling. I will always fight to uphold the sanctity of life."